dear students, today we are going to discuss judicial control of administrative action. The most significant, fascinating but complex segment of administrative law is that pertaining to judicial control of administrative action. The system of judicial review of administrative action has been inherited from Britain. It is on this foundation that the Indian courts have built the superstructure of control mechanism. The two important aspects of administrative law are the control mechanism over the administration and the remedies and reliefs which a person can secure against it when his legal right is infringed by any of its actions. From both these points of view, courts play a much more meaningful role than does either the legislature or the administration itself. It is an accepted axiom that the real kernel of democracy lies in the courts, enjoying the ultimate authority to restrain the exercise of absolute and arbitrary power. Without some kind of judicial power to control administrative authorities, there is a danger that they may commit excesses and degenerate into arbitrary bodies, and such a development would be inimical to a democratic constitution and the concept of rule of law. The whole law of judicial review of administrative action has been developed by judges on case-to-case basis. Consequently, a thickest of technicality and inconsistency surrounds it. Since courts occupy a key position in the scheme of Indian administrative law, an important question which needs to be discussed is what are the techniques available to the individual to bring his complaint or grievance against an administrative action within the cognizance of the courts, and what tools, subject to what conditions, and on what basis will the courts employ to afford relief to the complainant. In what cases do the courts feel that redress to a complainant is called for? The techniques commonly used for the purpose are writs, appeals, reference to the courts, injunctions, declarations, suits for damage for tortious actions of the administration and civil servants, and for breach of contracts between the state and the private persons, etc. Since the commencement of the Constitution, the most commonly used technique to bring an administrative action within the cognizance of the courts has been the writ system. Courts as final authority to determine legality of administrative action. Since the commencement of the Constitution, the most commonly used technique to bring an administrative action within the cognizance of the courts has been the writ system. Innumerable cases have taken place in this area, and hundreds of cases continue to be filed against the administration every year for seeking writs, and it may be no exaggeration to say that the writ process has overshadowed all other techniques of judicial review of administrative action. Now, dear students, let us understand writ jurisdiction. Articles 32 and 226 of the Indian Constitution make provisions for the system of writs in the country. Writs are issued by the Supreme Court and the High Courts under the provisions jurisdiction of the Supreme Court. Under Articles 32 and 136 of the Constitution of India, India has a hierarchical judicial system in which the Supreme Court of India is the apex court. It is the final interpreter of law and the ultimate court of appeal in all civil, criminal, and constitutional matters. It is also the final protection of people's fundamental rights. Judicial review is thus not only an integral part of the Constitution, which cannot be abolished or whittled down even by an amendment of the Constitution. In any democratic society, judicial review is the soul of the system because without it, democracy and the rule of law cannot be maintained. Thus, extraordinary jurisdiction of the court under Articles 32 or 136 of the Constitution of India cannot be taken away by legislation or principle of election or estoppel or even by amending the Constitution. The Supreme Court is invested with the power of judicial review under Article 32. Article 32, Clause 1 guarantees the right to move the Supreme Court for the enforcement of fundamental rights, and Article 32, Clause 2 invests the Supreme Court with the power to issue directions, orders, or writs for the enforcement of these rights. Now, scope of Article 32. Article 32 provides a guaranteed, quick and summary remedy for the enforcement of fundamental rights. Any person complaining of infraction of any of his fundamental rights by an administrative action can go straight to the Supreme Court for vindication of his right, without being required to undergo the dilatory proceedings from the lower to a higher court as one has to do in any ordinary litigation. The Supreme Court has thus been constituted as the protector and the guarantor of fundamental rights. Article 32 is itself a fundamental right and cannot therefore be diluted or whittled down by legislation and can be invoked even when a law declares a particular administrative action as final. Though the jurisdiction of the Supreme Court under Article 32 is confined to the enforcement of fundamental rights, yet if there is a clear abuse of process of the court, petition is maintained even if no violation of any fundamental right is involved. Now let us have a look on the case law. In the case of Express Newspapers Limited versus Union of India, Parliament enacted the Working Journalists Act 1965, which provided for the constitution of a wage board for fixing the rates of wages of the working journalists. The Act made no specific provision requiring the wage board to give reasons for its decision. This was challenged as unconstitutional on the plea that absence of an obligation to give reasons rendered the petitioner's right to approach the Supreme Court nugatory, because in the absence of reasons, the court would not be able to investigate the validity of the order made by the board. Rejecting the contention, the court held that the act would have been invalid had it prohibited the wage board from giving reasons for its decision. But as there was no such provision in the Act, and as it left it to the board's discretion to give reason for its decision or not, Article 32 was not infringed in any manner whatsoever. A notable aspect of Article 32 is that it can be invoked only when there is an administrative action in conflict with the fundamental rights provision of the petitioner. It cannot be invoked if no question of enforcing a fundamental right arises. The question whether a particular administrative action infringes the fundamental right or not, and therefore whether a petition under Article 32 to challenge it is maintainable or not, does at times raise complex issues. The classic case on the point is Ajambai versus State of Uttar Pradesh. A petition was filed in this case before the Supreme Court of India under Article 32 on the ground that a sales tax officer, by misconstruing a provision in a taxing statute, had imposed sales tax on the petitioner and thereby affected his fundamental right guaranteed under Article 19(1) Clause G. The Supreme Court held that since the order of assessment was made by the officer concerned within his jurisdiction, a mere misconstruction of a statutory provision by him would not justify a petition under Article 32, even though a fundamental right may be involved. The court stated that under Article 32, it would quash an order of a quasi-judicial body affecting a fundamental right if it acts under an ultra-vires law or without jurisdiction, or if it wrongly assumes jurisdiction by committing an error on a collateral fact, or if it fails to follow the principles of natural justice or to observe the mandatory procedural provisions prescribed in the relevant statute. But a mere error of law committed by a quasi-judicial body cannot be cured under Article 32. This ruling has come in for a good deal of criticism as it dilutes the efficacy of Article 32. The Ajambai ruling will not apply if the function is not quasi-judicial but executive. An executive order is amenable to Article 32 jurisdiction of the Supreme Court, and it is immaterial whether error of law or error of jurisdiction is involved. This view was expressed by the Supreme Court of India in Ghulam Abbas v. State of Uttar Pradesh. Now Article 136. This provision is in the nature of a residuary reserved power of judicial review in the area of public law. It lays down that the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal. Thus, Article 136 does not confer a right of appeal on any party, but it confers a discretionary power on the Supreme Court of India to interfere in suitable cases to advance the cause of justice. Even in cases where special leave is granted, the discretionary power vested in the court continues to remain with the court even at the stage when appeal comes up for hearing. Power under Article 136 of the Constitution, on the one hand, is an exceptional power to be exercised sparingly, with caution and care, and to remedy extraordinary situations of gross failure of justice. On the other hand, it is an overriding power where under the court may generously step in to impart justice and remedy injustice. Since the court has power to grant special leave to appeal against the decisions of administrative tribunals and other agencies, it is now regarded as an important mode of judicial review of administrative adjudicatory actions. Article 136 also refers to tribunals, a term which necessarily refers to a statutory body having the power to affect the rights of the people and a duty to act judicially. A tribunal for the purpose of Article 136 must have some trappings of a court of law, which include: first, that the proceedings before it must stand on an application in the nature of a plaint. Second, that it possesses the powers of a civil court in matters compelling the attendance of witnesses, discovery and inspection. Third, that it allows cross-examination and legal representation. Fourth, that it decides on the basis of evidence and according to law. And fifth, that its members are qualified to be judges. Normally, in exercise of its powers under Article 136, the Supreme Court does not re-examine the questions of fact. Unless the decision of the authority is patently perverse and manifestly unjust. In the case of Variety Emporium versus Muhammad Ibrahim Naina, though the Supreme Court reiterated that concurrent finding of fact by courts below shall not be highly interfered, yet added that this does not mean that injustice must be perpetrated because it has been committed by the lower courts. Therefore, if the concurrent decision is manifestly unjust, it is not only right but the duty of the Supreme Court to do justice. In the same manner, the court would not grant leave to appeal if other remedies of appeal and revision are available. But it is not a rule without exception. Finality clause in a statute excluding judicial review would not be a bar for the exercise of this jurisdiction by the Supreme Court. The court would not permit the plea of jurisdiction of the tribunal to be raised before it for the first time, but where a question of law is involved, the court may allow it. In the case of Ujagar Singh versus State Delhi Administration, popularly known as Vidya Jain murder case, the Supreme Court, rejecting the application of the special leave to appeal under Article 136, observed that it is time to realize that the jurisdiction of the court to grant special leave to appeal can be invoked in very exceptional circumstances. These exceptional circumstances, for instance, may include the following situations. First, special leave petition may also be granted where against the impugned order no appeal or revision lies. Second, a question of law of general public importance. Or third, a decision which shocks the conscience of the court. These instances are the prime requisites for the grant of special leave. Substantial question of law must be discernible from the pleadings. If pleadings are contemptuous, irrelevant, and incoherent and do not disclose any question of law, much less a substantial question of law, special leave petition is liable to be dismissed in limine. Special leave to appeal can be granted under Article 136 only against any judgment or decree of any court or tribunal. If the authority is neither a court nor a tribunal, no leave to appeal can be granted. In the case of Manju Verma versus State of Uttar Pradesh, question before the court was whether an order passed by the Chief Justice of the Allahabad High Court on administrative side to transfer a case from Lucknow bench to Allahabad bench of the High Court is a decision of a court or tribunal. The court held that the decision of the Chief Justice at best can be said to be a decision of a tribunal. The court clarified that the expression tribunal as used under Article 136 does not mean something as a court, but includes within its ambit all adjudicating bodies, provided they are constituted by the state and are invested with the judicial functions except those established under any law relating to armed forces. Granting special leave in the instant case, the court observed that powers under Article 130 can be exercised provided two conditions are present. The proposed appeal must be against a judicial or quasi-judicial order. The decision must be of a court or tribunal. In order to reach justice to the deprived and disempowered sections of the society, the apex court in the case of State of Karnataka versus A.B. Lugale held that the power of judicial review under Articles 32, 136 and 226 of the Constitution of India can be exercised to supplement changing social needs and values and felt necessities of the time, having regard to social inequalities, inequities, and imbalances the law intended to remove. However, the jurisdiction of the court cannot be invoked lightly. Keeping in view the congestion of the cases before it, the Supreme Court itself has suggested to the government to curtail its jurisdiction of special leave to appeal under Article 136. But because Article 136 is also a lawyer's paradise, the court always faces strong opposition from the bar. Now, jurisdiction of the High Court under Articles 226 and 227 of the Constitution of India. First, under Article 226. Article 226 empowers the High Courts to issue directions, orders or writs for the enforcement of fundamental rights and for any other purpose also. Thus, the power of judicial review of the High Courts is wider than that of Supreme Court. The words "for any other purpose" enabling the High Court to exercise their power of judicial review for the enforcement of ordinary legal rights which are not fundamental rights. The jurisdiction of the High Court under Article 226 for the enforcement of fundamental rights is mandatory, whereas for the enforcement of ordinary legal rights it is discretionary. The power of judicial review of the High Court under Article 226 is constitutional. Therefore, no measure of finality given by the legislature to any action or decision can take away this power. High Court is bound to follow the technical procedure of the English law in the matter of issuing a writ. Hence, a petition will not be thrown out because a proper writ has not been prayed for. High Court can issue a writ to a person or authority having its location or residence within the territorial jurisdiction of the court, or if the cause of action either wholly or partly arises within its territorial jurisdiction. Therefore, a High Court can issue a writ even when the person or authority is located outside its territorial jurisdiction. Now, power of High Court is supervisory under Article 226. The power of the High Court under Article 226 is discretionary and the power cannot be exercised as a court of appeal. The jurisdiction is supervisory in nature. It can strike down an impugned rule and direct the authorities to reframe it but cannot itself frame it. The power of judicial review under Article 226 is not directed against the decision but is confined to the decision-making process. High Court would interfere into the administrative decision if the same is mala fide or made in contravention of principles of natural justice or prompted by extraneous considerations or is in violation of any constitutional provisions or is such that shocks the conscience of the court. High Court, being a court of plenary jurisdiction, has inherent power to do complete justice between the parties, similar to Supreme Court's power under Article 142 of the Constitution of India. Article 227 of the Constitution. Article 227 vests High Courts with the power of superintendence over all courts and tribunals, including the administrative agencies exercising adjudicatory powers. The nature of this power is both administrative and judicial. Article 227, though confers the right of superintendence over all courts and tribunals throughout the territories in relation to which High Court exercises jurisdiction, but no corresponding right is conferred upon a litigant to invoke the jurisdiction under this article as a matter of right. In fact, power of superintendence casts a duty upon High Court to keep the inferior courts and tribunals within the limits of their authority and that they do not cross the limits, ensuring the performance of duty by such courts and tribunals in accordance with law. Only wrong decisions may not be the ground for the exercise of jurisdiction under Article 227 unless the wrong is referable to grave dereliction of duty and flagrant abuse of power by the subordinate courts and tribunals, resulting in grave injustice to any party. Judicial review of administrative policy. Norms of judicial review of administrative policy are more exacting and intrusive than the legislative policy. In case of administrative policy, there is more need of scrutiny and balancing. Courts are very reluctant to strike down legislation unless there is a clear violation of constitutional provisions. Court is not concerned with wisdom of the legislature but only with its legislative competence, and court will uphold the policy irrespective of court's own views. However, an administrative policy laid down by its rule-making power or in exercise of its executive powers can be reviewed if: first, it is unconstitutional; second, it is beyond the powers of the parent act or regulation; third, the delegate has acted beyond the power of delegation; and fourth, it is contrary to statutory policy or a larger policy. Executive decisions cannot be termed as policy decisions, and there is also no presumption of its constitutionality. Courts will apply doctrine of Wensbury unreasonableness and doctrine of proportionality in judging the validity of an administrative policy. The former says that a public authority acts unreasonably when a decision it makes is so absurd that no sensible person could ever dream that it lay within the powers of the authority. The latter envisages that a public authority ought to maintain a sense of proportion between his particular goals and the means he employs to achieve those goals, so that his action impedes on the individual rights to the minimum extent to preserve the public interest. This means that administrative action ought to bear a reasonable relationship to the general purpose for which the power has been conferred. Now, exhaustion of remedies. Ordinarily, availability of an adequate and efficacious alternative legal remedy is a ground for the court to decline to exercise its jurisdiction. But this principle does not apply to the enforcement of fundamental rights, either under Articles 32 or 226. The Supreme Court has stated in a number of cases that Article 32 being itself a fundamental right, mere existence of an alternative remedy is not a good and sufficient ground for it to throw out a petition for the enforcement of a fundamental right. Once the Supreme Court is satisfied that a petitioner's fundamental right is infringed, it is not only its right, but it is duty as well to afford relief to him. The issue of an appropriate writ in such a case under Article 32 is not a matter of court's discretion. It cannot refuse to give relief to him, and the petitioner need not establish that he has no other adequate remedy or that he has exhausted all such remedies as the law provides without obtaining redress. Similarly, it has been held that an alternative remedy is not a bar to move a writ petition in the High Court to enforce a fundamental right. With this, I conclude my lecture on judicial control of administrative action. Hope you enjoyed the session. For now, it is time to say goodbye. Stay blessed. Thank you.